MLAs and MPs are currently protected from criminal prosecution for bribes in connection with their votes and speeches in Parliament and legislative assemblies. But no more. The Supreme Court has ended this immunity that they enjoyed so far.
We have independently adjudicated on all aspects of the controversy, namely, whether by virtue of Articles 105 and 194 of the Constitution, a Member of Parliament or the Legislative Assembly, as the case may be, can claim immunity from prosecution on a charge of bribery in a criminal court. We disagree with and overrule the judgment of the majority on this aspect.
In its landmark verdict, a 7-bench judge of the Supreme Court disagreed and overruled the 1998 judgment in the Jharkhand Mukti Morcha bribery case. What was this 1998 bribery case that the Supreme Court ruled on? How is Jharkhand Mukti Morcha involved? And what did the Supreme Court say in its judgment? We explain in this video. The Supreme Court overruled its 1998 majority ruling in the Jharkhand Mukti Morcha bribery case on March 4th. Now, what was the 1998 judgment? To understand that, let's first set the context and understand these two articles that protected the MPs and MLAs. Under Articles 105(2) and 194(2) of the Constitution, legislators could claim immunity. Article 194(2) of the Constitution states, quote unquote, "No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such a legislature of any report, paper, votes or proceedings." Article 105(2) provides identical protections to members of Parliament and deals with powers and privileges of the Houses of Parliament. Back in 1993, Jharkhand Mukti Morcha MPs were charged with accepting bribes to save PV Narasimha Rao's minority government. The Central Bureau of Investigation registered cases against them. In 1998, a 5-judge bench in PV Narasimha Rao versus State interpreted these articles literally, and in 3:2 majority judgment held that the legislators enjoy immunity from criminal prosecution for bribery in matters connected to their speech and votes in Parliament and legislative assemblies. Cut to 2012, Jharkhand Mukti Morcha MLA Sita Soren was facing bribery charges in connection with the 2012 Rajya Sabha election. Sita Soren was accused of accepting a bribe from an independent candidate for voting for him. She had later claimed that she had voted for her party candidate, and a fresh election was held later in which she voted for her party candidate eventually. Sita Soren had moved the Jharkhand High Court for the quashing of the charge sheet and criminal proceedings against her, relying completely on the provisions of Article 194(2). But the High Court declined to do so. She then approached the Supreme Court. In September 2014, the 2-bench judge opined that the issue was substantial and of general public importance and should be placed before a larger bench of 3 judges. On March 7, 2019, a bench of 3 judges took up the appeal and noted that the High Court judgment dealt with the Narasimha Rao verdict and hence should be referred to a larger bench, and it was ultimately referred to the 7-judge bench. Cut to March 4th. After 25 years, the Supreme Court overruled the 1998 judgment, and this is what Chief Justice of India D.Y. Chandrachud said.
The judgment of the majority in PV Narasimha Rao, which grants immunity from prosecution to a member of the legislature who has allegedly engaged in bribery for casting a vote or speaking, has wide ramifications on public interest, probity in public life, and parliamentary democracy. There is a grave danger of this court allowing an error to be perpetuated if the decision were not reconsidered. Articles 105 and 194 of the Constitution seek to sustain an environment in which debate and deliberation can take place within the legislature. This purpose is destroyed when a member is induced to vote or speak in a certain manner because of an act of bribery. Bribery is not rendered immune under Articles 105(2) and the corresponding provision of Article 194 because a member engaging in bribery commits a crime which is not essential to the casting of the vote or the ability to decide on how the vote should be cast. The interpretation which has been placed on the issue in question in the judgment of the majority in PV Narasimha Rao results in a paradoxical outcome where a legislator is conferred with immunity when they accept a bribe and follow through by voting in the agreed direction. On the other hand, a legislator who agrees to accept a bribe but eventually decides to vote independently will be prosecuted.
The bench also comprised Justices A.S. Bopanna, M.M. Sundaresh, P.S. Narasimha, J.B. Parthivala, Sanjay Kumar and Manoj Mishra. If you want to know more about this case in detail, read our reports by Anant Krishnan G, Ajoy Sinha and Vidatri Rao. Links are in description below. Thank you so much for watching this video, and if you like this video, like and subscribe to our channel.